These plaintiffs say, look, we're saying that even if it's okay to do that generally, right? It's okay for this administration to deport somebody to a third country based on generalized assurances that the country will abide by the Convention Against Torture. The assurances in this case were bullshit from the get-go.
Welcome to Law and Chaos, where Newsmax is suing Fox again. James Comey's daughter Maureen is suing the Justice Department, and the ghouls at the Department of Homeland Security are going to make us all learn what chain refoulement is. We've got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
I'm good. How are you doing, Liz? Did you have a nice weekend?
I did, and I'm feeling good. I honestly have embraced my Diet Coke addiction. I was off it for a long time, and now I'm like, just be who you are. So I'm feeling bright-eyed and bushy-tailed.
To thine own self be true.
Okay, so let us start out with something fun, as is our habit.
I gotta take those wins where we can get them.
Yes, we do. So you may recall that about a week ago, we told you about the wingnuts at Newsmax suing Fox for doing the antitrust to them.
Right. So obviously, Fox News is the biggest kid on the fascist media block, and every cable and streaming company is going to carry it. Newsmax alleges that Fox illegally leverages that market dominance for Fox News to penalize those cable and streaming companies that carry Newsmax. Their argument is that Fox says, okay, Dish Network, if you want to put Newsmax in your second tier, fine, whatever. But if you want to put it in your basic tier, you got to put Fox Sports 2 and Fox Business Channel in there as well. So essentially, the allegation is that this is a chain tying arrangement. It's a financial penalty for the providers if they put Newsmax in a place where, people might actually accidentally watch it.
Well, not us. But, okay, so that case was filed in the Southern District of Florida, where it was assigned to Judge Eileen Kennan of Trump Documents fame, and she dismissed it without prejudice as a shotgun pleading.
Yeah, this was very silly because what Newsmax did here was a very technical mistake. Let me see if I can't unpack it. A complaint follows a typical format. Paragraph 1 is the summary of your allegations. It's the story, the roadmap of what you allege the defendant has done and what you want the court to do. Then, typically in a complaint, the next few paragraphs are a jurisdiction and venue section, why it is permissible for you to have filed this complaint in the court where you filed it. Then you identify the parties. Then you set out the facts. And let's say that's 50 paragraphs. After the facts, you then specifically plead your causes of action, right? That is count 1, breach of contract, count 2, tortious interference, count 3, negligence, so on, right? So the way in which you plead this is that paragraph 51 will say, the allegations in paragraphs 1 through 50, those are the facts, are hereby incorporated herein by reference. And then you'll plead the elements of breach of contract. And then count 2 starts over again, right? You're now at paragraph 60, but you'll say, paragraph 61, the allegations in paragraphs 1 through 50 are incorporated herein by reference. Each new count incorporates the facts, but not the allegations from the previous causes of action, right? Obviously, this is boilerplate, right? We lawyers just cut and paste the same paragraph and let MS Word number it for us, right? But now I want you to imagine that instead of repeating 1 through 50, you say the allegations in the above paragraphs are incorporated by reference. So then, technically, count 2 incorporates not just the facts, but all of count 1. Count 3 incorporates not just the facts, but all of counts 1 and 2. And by the time you get to, let's say, count 9, it includes your entire complaint. So don't do that. But this is basically a typo, right? And what Judge Cannon did here was something I have never seen a judge do ever. She sua sponte, that is, on her own initiative, read the complaint, said, this is a shotgun pleading, I'm dismissing it, Newsmax, start over. And like I said, that's silly, because all Newsmax had to do was amend and change some line numbers, right? That's you don't do that.
Right. Well, and to be clear, we make fun of a lot of garbage litigation, a lot of garbage defamation litigation specifically on this show. And that's not what happened. These aren't like incompetent lawyers. These are experienced antitrust counsel.
This is a real lawsuit. Yeah. I'm not saying they're going to win, but it's not laughable.
Right. Like this wasn't, get out of my courtroom nonsense. This was like, as you said, a typo. But when God closes a door, she opens a window.
A bathroom window. And she throws classified documents out at it.
Yeah. So Judge Cannon gave Newsmax a week to amend the complaint and refile. But they decided they would rather not, thank you very much. And so they decided they'd head north. Way north to the Western District of Wisconsin, and they refiled their case there, more or less just crossing out violates Florida's antitrust and consumer protection laws and replacing it with violates Wisconsin's antitrust and consumer protection laws.
Along with the Sherman and Clayton Acts, which are the main federal antitrust statutes.
Right. And okay, I should say this is probably legal to just refile it somewhere else, right? Fox is clearly transacting business in Wisconsin. It owns properties there. Jurisdiction there is fine, probably. Yeah. And look, the plaintiff is master of her complaint. She, or Newsmax in this case, can file it wherever she wants. I don't want to presume Newsmax's pronouns. Maybe the network goes by Caesar. We respect it all.
Indeed, we do. So I do wonder what Newsmax is thinking here. I mean, don't get me wrong, getting out from under Eileen Cannon, always a good idea. But the Southern District of Florida is huge. It has a ton of Republican and Democratic appointees. You never know what you're going to get. But not the case in the Western District of Wisconsin, where there are just 2 appointees to the federal bench, both of whom were appointed by Obama. That is Chief Judge James Peterson and Judge William Connolly. Now, they drew Connolly. Obviously, the calculus here was that they did not want a Trump-friendly judge, but I'm not sure why.
Yeah, I'm not sure why you would file in the Southern District of Florida in the first place.
Oh, right, yeah.
I mean, I appreciate that Newsmax is a Florida company, or it's domiciled in Florida or whatever, does business out of Florida. But if they didn't want a Trump judge, they definitely had options. But,
I'm going to go out on a limb here and suggest that Newsmax is very well aware that Eileen Cannon sits in the Southern District of Florida.
Right. As does, Judge Donald Middlebrooks, a whole bunch of different judges. Like if they wanted to rig this game, they could have rigged it the first time. But all right. Well, Godspeed to Caesar. Okay, another fun one for us in the case of Hunter Biden v. Overstock weirdo Patrick Byrne. Biden is suing Byrne for defamation, and this case is like an amazing shit show dumpster fire. Mostly because Byrne is out of his goddamn court.
He is indeed. We have talked about this case a lot. This is the one where Patrick Byrne fired his longtime lawyer on the day of trial and tried to substitute in Stephanie Lambert, the bestest election lawyer in the whole wide world.
I mean, just ask her, she'll tell you. She is also the lawyer who has pending charges against her for election-related crimes in Michigan and managed to get herself picked up on an outstanding warrant in the courtroom in D.C., where she was representing Byrne in yet another case.
It didn't deter him at all. That case was Dominion's defamation suit against Patrick Byrne, and Lambert got herself disqualified by the judge after she repeatedly leaked discovery materials. In fact, her attorney login in violation of a protective order. So, long story short, Byrne, day of trial, had no lawyer. The judge kind of hyperventilated for a while about how this was the craziest circus he'd ever seen, and then postponed the trial till October, which was the 3rd postponement, which seems to be giving Byrne what he wants. But meanwhile, Patrick Byrne has never so much as shown his face once in that court, has no lawyer to accept service of documents, and is ignoring court orders, despite the fact that the judge said, if you do not hire a lawyer, Mr. Byrne, and show up in this courtroom in person to tell me you're going to start acting right, something very bad will happen to you.
Yeah, we should say that Byrne is a billionaire who appears to live overseas. He largely ignored this case even when he was represented by counsel. And since firing his lawyers, he's totally ignored it, for like a month now.
Yeah. So On August 28th, Judge Stephen Wilson of the Central District of California gave Byrne 14 days to show cause why he should not be held in contempt. And that show cause order was written in the strongest possible terms, right? Judge Wilson spent 5 pages explaining just how badly Byrne had behaved in this case. And then he talked about the court's available remedies. We'll read a little bit here. This may include the application of substantial monetary sanctions on defendant for each day he fails to respond to plaintiff's discovery requests or appear personally before the court. However, considering defendant's alleged wealth, and in light of the fact that defendant has failed to make even one personal appearance before this court may well calculate that a bench warrant for defendant's arrest is the only reasonable mechanism for ensuring that defendant appears as ordered. Otherwise, if the above sanctions prove ineffective, default judgment in favor of plaintiff may be appropriate as a last resort.
Wow. Bad things will happen to you if you keep flipping off the court. So, on Saturday the 13th, Hunter Biden's lawyers filed an application for a bench warrant. They want the court to issue a warrant for Byrne's arrest, and their reasoning is interesting. Because, look, when we were first thinking about this case, I was like, well, Patrick Byrne may live in Dubai or Narnia or Krypton. Who the hell knows? But at least, right. Some of his money has to live here in U.S. America. Right. But Biden alleges that Byrne is socking away cash in places where the court cannot actually get to it. So he says entry of a monetary sanction or default judgment would not obviate the need for the court to use its coercive powers to enforce its orders in this case because defendant is a billionaire who ignores court orders while concealing his assets overseas or in cryptocurrencies specifically created to evade governmental authority and who flouts this court's authority. The appropriate sanction is to force defendant to appear and defend or confess the case on the merits. The court has repeatedly ordered defendant to appear, and defendant has repeatedly ignored the court. Plaintiff therefore respectfully requests that the court compel defendant to appear by issuance of a bench warrant.
Yeah, haul his ass into court. Now, to be clear, a bench warrant is not where the marshals go get this guy and throw him in jail. It is go get this guy and bring him before the court to secure his appearance. Ironically, it's what Stephanie Lambert got picked up on when she was in D.C.
Yeah, this case has a lot of layers. Incidentally, for those of you in law school who are just like thinking about what is it that lawyers do all day? Well, the affidavit supporting this motion was filed by the law firm's clerk, Emily, who is a third-year law student at the University of South Carolina. So remember, Byrne has no lawyer, and he's not accepting service of process. So Biden's lawyers have to prove that Byrne got notice of the court show cause order because they got a bunch of big asks teed up. First, they want the marshals to pick this guy up, and then they want a default judgment, which is a lot, right? You can't spring that on somebody. So they know there is one place you can always find Patrick Byrne, and that place is Twitter.
InfoWars?
Yeah. Well, that's true, too. But Byrne is constantly shouting inanities on Elon Musk's health site. So the law student, Emily, set up an account at clerk841635 and spent a week where every time Byrne barfed out a tweet, she replied to that tweet with a PDF of the court show cause order. And then she got to swear out this affidavit saying, this is what I did. I spent a week shitposting at Patrick Byrne. And then she attached the screenshots. Actually, funny enough, one of those Byrne tweets was a reply to Stephanie Lambert's crazy ass conspiracy tweets. Amazing. The whole thing is
he
so
can
circular.
Talk to her on the phone anytime he wants. Oh, okay. Thoughts here.
So Emily swears out this affidavit, attaches all her screenshot, and says, Your Honor, here is our evidence that this jackass Byrne got actual notice of your show cause order.
Right. Couple of thoughts here. Number one, good job, Emily, right? The firm should 100% make you an offer at the end of your 3L year.
Absolutely.
Number two, the Ninth Circuit has approved service via Twitter. So there is case law that says in alternative means when a defendant appears to be ducking service, they have approved of service via Twitter. Mm-hmm. And also, I just have to say, this case is bizarre to me.
So
right?
crazy.
To be clear, Hunter Biden is not, this defamation lawsuit is not about the horrible stuff that Patrick Byrne said about Hunter Biden doing bribery with Ukraine, right? That was definitely defamatory and super bad. But the statute of limitations has likely lapsed on most of those statements, or if not all of them, right? It's going to be 1 or 2 years, depending on the jurisdiction. This suit is about something Byrne said in a much more recent 86-page interview with a press that I think Byrne funds, or I don't know, some magazine no one has ever read.
Right.
And it accuses Hunter Biden of taking bribes from Iran. And let's be real for a minute. How much damage can one random statement in 2024 do to a guy whose name is functionally synonymous with sleazy screw-up, right? Anybody's going to believe this has already seen the movie My Son Hunter, right? Look, my point is that Patrick Byrne is not without meritorious legal defenses to this lawsuit, right? Like, I do not know why he is essentially daring this court to default him and default him for, I don't know, 7 figures, right? Like a sum of money that is meaningful even to a billionaire.
Yeah, I find the whole thing confusing, but, he's a confusing guy and sometimes confused. Okay, so this afternoon, Judge Wilson set a date for the show cause hearing, and in case Patrick Byrne wants to show up and explain himself, but we are going to laugh uproariously during this brief ad break unless you're a subscriber. And we're back. Okay, today, Maureen Comey, the daughter of James Comey, the former director of the FBI, sued the Justice Department, which is wild, since until about 9 weeks ago, she was a distinguished prosecutor at the Southern District of New York. In fact, she was the lead prosecutor on the Jeffrey Epstein case back in 2019, and then she led the Ghislaine Maxwell trial, as well as the prosecution of Senator Bob Menendez and his lovely wife Nadine. Maureen Comey was part of the team. Yeah, Maureen Comey was part of the team that prosecuted Sean Combs. And then on July 16th, she was abruptly terminated at the explicit behest of the White House while she was in the middle of multiple trials and without regard for her long esteemed track record with glowing reviews.
Yeah.
Comey says that the precipitating event was a sustained attack over several weeks by Laura Loomer, the right-wing provocateur who is close to Donald Trump, but not that close, we should say, because Laura Loomer's suing Bill Maher for suggesting that she's sleeping with Donald Trump and whatever. No comment.
Right. Zero comment on that, except to say, really nice to see the party of free speech, y'all.
Yeah, after this week.
Okay. So Maureen Comey alleges a whole host of due process and retaliatory causes of action, and I'm not sure how I rate her chances in this legal environment. Mm-hmm. The Supreme Court has made it abundantly clear that they're going to let Donald Trump fire literally the entire federal bureaucracy. But I think this case is really interesting on a couple of valences. So first, as a federal employee, Comey would ordinarily be obligated to go to the Merit Systems Protection Board. That's how you exhaust your administrative procedures. But as we've discussed on the show, the Supreme Court let Donald Trump fire the members of the Merit Systems Protection Board, and now there is no quorum, so that agency is functionally dead. The administrative judges can hear civil service cases and issue orders, but the board cannot finalize them. And there's also a little matter that the president has said that the Merit Systems Protection Board is unconstitutional because all power flows from Donald Trump, and if the king says off with her head, or in this case, you're fired, the MSPB's determination cannot bind him. So Comey alleges, at present, the government not only disputes the constitutionality of the Civil Service Reform Act, but has taken action to render the MSPB ineffective by removing the member of the board necessary to ensure a quorum exists, and removing the one member who is from a political party other than the president's.
Right. That's because under the Merit System Protection Act, the board needs 3 sitting members, at least one from each party, and one of the Republicans resigned, and then Trump fired the only Democrat. So there's one board member left. That's a Republican, and that's not a quorum.
And one is not a quorum even in Donald Trump's America.
Right.
So, Comey continues. As a result, plaintiff need not exhaust her administrative remedies before the very agency that the government both argues is without administrative power or authority and has taken steps to strip of its power and authority.
You make a valid point.
Yeah, I don't know where that's going. That's an interesting argument, right? If the president kneecaps the administrative agency that hears civil service employment disputes, is he still entitled to force civil servants into the administrative process, right? It's not a real process at all at this point. It's just a dead-end cul-de-sac, and one that the president himself has said is illegal anyway.
Yeah, it would seem to me to be pretty untenable in this posture. But what strikes me is how goddamn stupid it was of the government to fire her. Right? Maureen Comey is a really good prosecutor. She's a superstar. She was doing really good work, and she was doing it for a whole lot less money that she's going to make in the private sector. And all of that was a benefit to the government. But as a benefit to the Trump administration, keeping her inside the tent, employed, by the government, meant that she wasn't going to use her voice or her considerable talents to attack the Trump administration.
Or, let's say, her last name, right? Everyone is going to know who Maureen Comey is.
Right, exactly. So, they pushed her out, right, as they pushed out her father in the first Trump administration, and now somebody who was going to be a loyal civil servant and shut the hell up is not. And I think it's very clear that she's not. She filed this lawsuit that was really a public declaration that she was going to take aim at the Justice Department. So now, in addition to perhaps representing criminal defendants, which is what a lot of prosecutors go out and do, maybe she becomes, like Mary McCord Andrew McCabe doesn't practice law. He was one of the fired FBI agents. But a lot of these people who have left, say like Preet Bharara, right? Preet Bharara was the U.S. attorney for the Southern District of New York, who was fired during the first Trump administration. He went on to become a really prominent critic of the administration. Like lots of the people that they pushed out have really big second careers, either as people in media who criticize the administration and take apart what it's doing wrong, or they sue the administration with Lawyers Defending Democracy or some of these really strong, good government organizations. So, they could have stopped this. The Trump administration didn't have to make this woman their enemy, and now they have.
I mean, trying to parse Donald Trump's enemies list, he's demented. James Comey is probably the single person on earth most responsible for Donald Trump winning the election in 2016. I don't know, Nate Silver, Jill Stein, but it's a short list. He should be on Trump's heroes list, but our president is demented, and nobody says that's a dumb grudge. Anyway, I'm ranting. This is some death of Stalin level strategy going on here.
Amazing. Okay. So, as we've said before, we get a lot of comments on social media and direct messages and emails saying, the law isn't real. None of this matters. Why do you guys keep talking about this? The Supreme Court's just going to blow it up anyway. And it's certainly understandable that a lot of people have, defeatist sort of takes at this point and feel really hopeless. And so I think it's important for us to point out times when the law, and particularly all of the lawsuits that we talk about, really does matter, really changes things. And as we've said, it's changed a lot in these immigration cases, even as it happens sometimes in cases where the Supreme Court tries to throw a spanner in the works. So let's talk for a second about a case in Rhode Island called California v. McMahon. The McMahon here is Linda McMahon, the wrestling impresario with a bachelor's degree in French, who is somehow the Secretary of Education for our poor, beleaguered country.
In the Bud Fox sort of way, right? She is only secretary until Trump shuts down the Department of Education.
You shut your filthy mouth, sir. So, okay. This was one of the lawsuits filed by a coalition of blue state attorneys general. And as we've said, they meet every morning. They have a Zoom call at noon Eastern time, and they talk about who are we going to sue next? What is the strategic way we can do this? And so massive props to them. So this lawsuit challenged cuts to $6 billion in education grants for stuff like adult literacy and English as a second language, or I believe that it has a different term now. I believe we don't say ESOL, so no disrespect. It cut grants for classroom technology, which is all woke shit. And so the blue states sued, and that case proceeded, but in parallel with the litigation, the parties negotiated, and then they reached a stipulated settlement in August, late August.
Right. And I want to underscore just how significant a win that is to the plaintiffs, right? A stipulation means both parties agreed to this. The government didn't have to, and they essentially plea bargained to the death penalty, right? They agreed to each and everything that the plaintiff states wanted. And so I think if your position is, it doesn't matter when you sue the Trump administration because they will just run to the Supreme Court and the Supreme Court will say it's okay for them to cut off your money, like that didn't happen here.
Right. And so, as a direct result of this lawsuit, the plaintiff states got their money. The Department of Education released the first tranche, agreed to release the second tranche. Now, they're not going to concede that they actually have to follow the law and spend the money allocated by Congress in the budget bill, but they forked it over. It really did happen.
Right. And that is the incentive from the government's perspective to enter into the stipulation rather than get an adverse judgment that stands up on appeal, right? So again, think about what that means. That says that the government either did not have the time to litigate this out or had concerns that the Supreme Court was not going to bail them out. And both of those are really good results. And both of those are a reason to keep fighting from every direction as hard as we can.
Right. This litigation mattered. Okay. It is Tuesday, so we are going to thank our subscribers.
Yeah, a big thank you to those of you who signed up over at patreon.com/lawandchaospod. So our new patrons, Graham Doherty, Jamie, Aline Flores, Gina, Rubik's Tesseract, love that name, Jason Garinge, Christo Gerber, Madeline Blue, Brendan Liddy, Andy Halsey. Thank you so much for supporting the show.
And over on Substack, thank you to Mary Jane Levasseur, Candace Hall, Freddie, and founding subscriber Jonathan Beard.
And if you'd like to join their ranks, if you'd like to get the shout out here and help support this show, keep us going, plus you get all the episodes ad-free, you get the bonuses, you get all the goodies, including a segment on yet more good news, then you know how to do that. Just head on over to lawandchaospod.com to sign up on Substack or on Patreon to patreon.com/lawandchaospod. Give us as little as $1 an episode and you will get all those goodies. Plus, you will know that you are making this show possible. So for our subscribers, we have an extended segment here on a ruling from the Northern District of California. And for everybody else, we'll see you on the other side of this brief ad break with another story. And we're back. On Friday, yet another U.S. District Court judge in Washington, D.C. was asked to jump in and issue emergency relief to try and stop another humanitarian tragedy engineered by the Trump administration. This case is captioned DA versus Noem, and we wrote about it for our blog at lawandchaospod.com yesterday, and we're going to talk about it now.
All right, so here is what happened. On September 4th, the government rousted 14 detainees from the African nations of Nigeria and the Gambia from their beds in the middle of the night and informed them that they were about to be deported. These immigrants all had final orders of removal. That is, the immigration courts had ruled that they could be deported, but they also had orders withholding removal to their home countries based on credible fear of persecution or torture. One of these plaintiffs, KS, is bisexual. The Gambia has draconian laws against same-sex relations. In 2014, the criminal code was amended in Gambia to add the crime of aggravated homosexuality for serial offenders. That's punishable by life in prison. A single instance of sexual acts, quote, against the order of nature carries a 14-year prison sentence. So KS obviously stands a strong chance of being persecuted for his immutable characteristics. That's the language of the statute if returned to the Gambia. And so the immigration judge said, no, U.S. government, you can't send him there.
Right. So what the government did instead was ship KS and the other 13 detainees to a third country, Ghana. And then Ghana turned around and immediately sent KS to the Gambia for us. The complaint alleges that this was not a mistake. KS says that there were 6 ICE officers and some military personnel on that flight from the U.S. to Ghana, and that during a refueling stop at the U.S. Virgin Islands, the person that he perceived to be the head ICE official on the plane told him and the others that they were being sent to Ghana and that Ghana would send us to our home countries. Several of the detainees have already been repatriated to their countries of origin in West Africa, and the ones who remain in Ghana are imprisoned at a remote outdoor detention facility called Dima Camp. KS says that Ghanaian officials ignored his protests when he said he could not be repatriated to the Gambia. They told him that he was being sent back pursuant to the agreement between the U.S. government and Ghana, and then they did, in fact, deport him to the Gambia, despite the fact that he had no official paperwork. He is now in hiding. So, the technical term for what the U.S. has just done here is chain refoulement.
Right. So refoulement is the forcible return of refugees or asylum seekers to a country where they face persecution. It is illegal under both U.S. law and the UN Convention Against Torture, or CAT, of which the U.S. is a signatory. It's why these detainees had final orders of removal, but orders of withholding, saying the U.S. could not send them back to Nigeria or Gambia. Chain refoulement is using some third country as a cutout or pass-through to refoul someone you cannot repatriate directly, which is what the plaintiffs here are alleging. They say that the U.S. pressured Ghana to act as functionally a refoulement hub in West Africa because there's visa-free travel between Ghana and several of its neighbors. I believe that what they're referring to in the papers here is ECOWAS, the Economic Community of West African States, which includes Benin, Burkina Faso, Cabo Verde, Cote d'Ivoire, the Gambia, Ghana, Guinea, Guinea-Bissau, Liberia, Mali, Niger, Nigeria, Senegal, Sierra Leone, and Togo. You could think of it as analogous to the Schengen area in the EU, which allows for a movement of people back and forth. And there's a lot of people, right? These countries have a population of almost 500 million people together. So you can understand why having a buddy inside ECOWAS willing to accept West African deportees would be very useful in the U.S.'s effort to rendition millions of people. And if Ghana can just act as a pass-through to refoul immigrants from those 15 countries, then the U.S. can more or less ignore or evade orders from our own immigration judges withholding removal for basically all of West Africa.
Yeah. I want to emphasize here that the principle of non-refoulement is a fundamental rule of international human rights law in exactly the same way that it is illegal for countries to bomb hospitals or use civilians as human shields or torture prisoners. It is, as the UN has described it, without exception. The principle applies to all persons, regardless of their citizenship, regardless of their legal status, the crimes they are alleged to have committed or have committed, and it applies whenever a state has jurisdiction or effective control over someone, right? Even if that control is outside of a state's territory. It is, Liz, as you said, prohibited by the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment. It is also prohibited by the International Convention for the Protection of All Persons from Enforced Disappearance. It is prohibited by the Inter-American Convention on the Prevention of Torture, by the American Convention on Human Rights, and by the Charter of Fundamental Rights of the European Union, just to name the first 5 treaties off the top of my head. Refoulement is torture, and the Trump administration is doing it. So, the plaintiffs, 5 of those 14 people who were sent to Ghana, including KS, filed a lawsuit on Friday that got assigned to Judge Tanya Chutkan of the U.S. District Court in the District of Columbia.
Right, and Judge Chutkan is, I'm sure, familiar to listeners of the show. She is the judge who oversaw U.S. v. Trump, the election interference case, which was shut down by the Supreme Court in Trump v. U.S. in the immunity case. Mm-hmm. Okay, so so she has tangled with Trump before. She knows what it's like to be in Trump's crosshairs. She's very strong. So, okay, this case raises a whole lot of legal issues, and it highlights the reason that the Department of Homeland Security keeps whisking groups of detainees out of the country, or trying to, in the dead of night, because what they're doing is illegal, and they want to get all these immigrants outside the country where they're functionally outside the jurisdiction of the courts. Basically, they want to, make it so that it's moot, that any case is moot before it can even be heard. Right. But from the Abrego Garcia case, we know that courts can order the government to facilitate the return of an immigrant who's been wrongly deported, even if that immigrant is outside of the United States. That language was blessed by the Supreme Court itself, but it's a heavy lift, and facilitate is kind of a wishy-washy term. So at this point, the plaintiffs are simply trying to persuade Judge Chutkan to order the U.S. government to facilitate the Ghanaian government into not refouling these deportees to the Gambia and Nigeria.
Right. And the government says that this case is not like Abrego Garcia or JOP, that is the case of the protected class of child arrivals who were still deported despite a binding court order. There, the plaintiffs had binding court orders saying it was illegal to deport them to El Salvador. And the holding of each of those cases is that once a deportee can show that he doesn't belong in the country to which he's been sent, then the government concedes that a court can indeed order them to facilitate, but not effectuate, as you point out, Liz, the return of that person. But here's their argument. They say here, plaintiffs ask this court to put the cart before the horse, order the government to facilitate particular arrangements with a foreign nation for the benefit of an alien before there has been any finding that the alien's removal was unlawful or otherwise erroneous. And we will be back to break down that argument after this brief ad break. And we're back. Okay, so the government is arguing that this case is different from Abrego. And there are really two components to that argument. So first, they say it was reasonable, not illegal, and definitely not a mistake for the government to have deported any of these individuals to Ghana under guidance that was issued by Homeland Security Secretary Kristi Noem on March 30th.
Right. So that guidance memo says that an immigrant who has a final order of removal but cannot be sent to his home country can be removed to a third country, quote, without the need for further procedures upon receipt of diplomatic assurances that aliens removed from the United States will not be persecuted or tortured. So the government can, according to this memo, snatch these people up and load them onto planes without even telling them where they're going, so long as Kristi Noem got a Post-it note from a friendly dictator saying, "No torture, I promise, heh, heh, heh." Incidentally, there was a court order that said the government had to provide notice and an opportunity for these deportees to make CAT claims about whether they, that they might be tortured in the third country. That is, the court said that they were entitled to more process than the Noem guidance memo accorded to them. But the Supreme Court, as its habit, crossed that court order out on the shadow docket. That was the DVD case we've talked about a lot. In that case, the government tried to disappear all of these Southeast Asian immigrants to South Sudan, which you will note is not in Asia. And notably, the South Sudanese government said, "We are not keeping these people. Our plan is definitely chain refoulement," which, by the way, so did the Ghanaian government in this case.
Right. So as all of this is developing, at the emergency hearing on Friday, Department of Justice lawyer Elianis Perez said, "Look, we got the assurances from Ghana per the Noem memo, so it's not our fault if they turned around and refooled these guys." Wink, wink, right? Well, he left out the winks. But it was definitely implied, and Judge Chutkan made multiple references to a wink and a nod. Like, no one in that courtroom actually believed that this was not the Trump administration's plan all along. And the government is being incredibly cagey here. They have not confirmed, as of this recording, that those assurances were in writing. And if they are in writing, they certainly have not been given to the court or to the plaintiffs. What the government did turn over was an affidavit from Jonathan Pratt, who heads the State Department's Bureau of African Affairs. And no, you and I can't see it.
Not to defend the government here, but that one is sort of on Judge Chutkan.
Yeah.
Because during the hearing, she said the plaintiffs are entitled to see the actual agreement. But then the order she put out after the hearing said the plaintiffs are entitled to a declaration explaining the government's posture. And that is what they got. Like, maybe the government should have attached the agreement. I think that they should in the normal course. But the State Department flatly refused to turn over the agreement governing the deportation of Venezuelan nationals to El Salvador in the Abrego Garcia and JGG cases, right? There was no way they were going to turn that Ghana agreement over without the government ordering them to, and maybe not even then.
Yeah, and we have seen district courts, right, in light of JGG saying on the record, counsel, you understand my oral orders right here are binding, right? Like,
right.
You got to dot your I's and cross your T's with these folks. Otherwise, they will do what they did here. So, okay, the Pratt Declaration was filed without an attachment and under seal and was turned over to the plaintiffs subject to a protective order. But although we can't see it, I think it is safe to assume that it was as vague and as squirrely as the ones that we saw on the public docket in the Abrego Garcia case, right? Just a couple of paragraphs saying, Ghana said there's no torture. We can't say anymore because national security, the State Department, sensitive diplomatic negotiations, blah. Right, exactly. So on Monday, the plaintiffs filed a motion to compel the government to turn over the actual written agreement between the U.S. and Ghana. Here's what they ask for. At the time of filing, the government has yet to provide either that agreement or evidence that such an agreement does not exist. Indeed, mounting evidence suggests that such an agreement does exist and has been reduced to writing. Production to plaintiffs should therefore be compelled immediately. And then that actual evidence, there's a page of citations to news reports, to public statements by the Ghanaian foreign minister that refer to a memorandum of understanding between the U.S. and Ghana. So it does seem like it exists, but as of 8 p.m. on Monday night, we are still waiting to see what the government says.
Right. But even as we have been recording, there is another filing on the docket from the plaintiffs laying out even more evidence that this agreement exists and is in writing. There were multiple references by Ghanaian officials today to a memorandum of understanding that had been reduced to writing, that they had a copy of it and the terms of it. So it's out there. It's been publicly reported, and the government can't colorably argue that they shouldn't have to turn it over. I mean, I'm quite sure that they will because I've played this game before, but okay. So the second argument that the government is making is that if these plaintiffs want to challenge their initial deportation to Ghana, they have to do that as part of the class of plaintiffs that was certified in that case, DVD v. Department of Homeland Security. Remember, that's the one we just talked about a minute ago in the District Court of Massachusetts, where Judge Brian Murphy tried to give those detainees more process before they were removed to a third country. And the Supreme Court said, nope, and, just took a Sharpie to the whole order. So the government, in this case, would very much like to shift these West African deportees to Judge Murphy's courtroom, particularly because Judge Murphy's case is now bogged down by this Supreme Court shadow docket order. So, he can't do anything. So what the argument here is that the West African plaintiffs are covered by the class certified in DVD, and thus they can't bring a separate lawsuit before Judge Chutkin.
Right. And this is a difficult argument for these plaintiffs, right? Because the plaintiffs here say, no, we should not be included in the DVD class because that is about the legality of the third country removal policy itself, right? Like that lawsuit challenges that March 30th Kristi Noem menu. These plaintiffs say, look, we're saying that even if it's okay to do that generally, right? It's okay for this administration to deport somebody to a third country based on generalized assurances that the country will abide by the Convention Against Torture. The assurances in this case were bullshit from the get-go. The government knew Ghana was going to chain refool anybody we sent there, and so those assurances were a legal nullity. And the fact that ICE agents on the plane said, you're going back to Nigeria and the Gambia is pretty good evidence that the agreement was a sham. Like it wasn't even a wink and a nod between Marco Rubio and some high-ranking Ghanaian official. If the guys wearing flak jackets and taking shackled detainees to the bathroom knew it, it was official U.S. policy.
Yeah, I think that's exactly right. Okay, we're going to take one more ad break unless you're a subscriber at patreon.com/lawandchaospod or at lawandchaospod.com, in which case there will not be an ad break for you. Not today, not ever.
Okay. Now, let's talk about the government's last argument, because this is one I keep skipping over in all of these immigration cases because it is so obviously stupid. It is so obviously in bad faith that, I cut it for time. But it keeps coming up.
Yeah.
So I feel like we should talk about it. We never know when Justin Walker or the Supreme Court is going to seize on it and be like, exactly, right? So, as background, Liz, as you pointed out in the last episode, the Bill of Rights does not use the word citizen. It speaks of rights of the people, whether you're a citizen or not. And the 14th Amendment is a little bit more nuanced. It says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So you see those different categories, right? Citizens, persons within its jurisdictions, persons, period. It creates a bit of a confusion. So in practice, when we're talking about immigration cases, it means that individuals have no constitutional rights as an alien seeking admission into the United States, right? Even if your spouse is here, even if your kids are here. But once you have physically entered the country, you do have the right to due process. You can, for example, assert the writ of habeas corpus. I promise you, Liz, that I will not rabbit trail. We're 60-odd minutes in, but that's why it's a big deal that the Trump administration has rewritten the rules and practices on expedited removal, right? Because expedited removal is supposed to be this emergency process for aliens that are encountered within 100 miles of the border within 14 days of their arrival. So it has, from a legal perspective, fallen on the seeking admission side of the ledger where you don't have constitutional rights. But now the Trump administration wants to use expedited removal for anyone found anywhere at any time.
Yeah, and in fact, I read today that he wants to go to the UN and change the entire definition of asylum seeker and refugee because he's the devil.
Yeah, maybe we'll get North Korea's vote on that. But okay, look, that's the constitutional rights framework. And what it means is that, broadly speaking, Congress has plenary power when it comes to three kinds of decisions: who to let into the country, who to remove from the country, and how to remove them. So in those three cases, you, as the alien, get the rights that Congress says you have, if any.
Right. And one of the ways that's implemented is through 8 U.S.C. Section 1252, which places limits on what kinds of decisions are subject to judicial review. So, for example, when an immigration judge issues a final order of removal or denies your asylum claim, you can't go to a district court and file another lawsuit. You get one crack in the relevant Circuit Court of Appeals, and they're only reviewing the determination for legal error or abuse of discretion. So that means if an immigration finds as a matter of law that your testimony was not credible, you're basically stuck with that finding. And all of that is legally permissible.
Right. But here's what's not, because those limitations on judicial review are very specifically circumscribed given that constitutional rights framework that we just went through. Subsection G, right, 1252G, as you've suggested, Liz, applies only to the decision or action by the Attorney General to commence proceedings, adjudicate cases, or execute removal orders against any alien under this chapter. And this is one of those recent provisions of the law. Like, we know exactly why this section was enacted in 1996. It was to prevent potential deportees from filing lawsuits that say, hey, you tried to deport me, government, but you didn't try to deport lots of other people that are in the same situation I'm in or even worse. So effectively, it was intended as a kind of prosecutorial discretion, right? Like, you, as someone subject to removal, cannot second guess who the executive branch wants to kick out of the country so long as they follow the law.
Which is not what happened here at all. All of these plaintiffs have already been through the immigration process. The government began removal proceedings and got final orders of removal, but each and every one of these men won orders from the immigration court withholding their removal to their country of origin, right? They're not trying to litigate any of those decisions. They're not challenging the execution of their removal orders. But importantly, all of these limitations on But importantly, all of these limitations on judicial review are subject to the exception that you can always raise a habeas petition. And that right comes from the Constitution. It's Article 1, Section 9, Clause 2. It's called the suspension clause. And it says that the privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it.
Right. One of the fundamental protections we give to people in this country. And I will point out that the suspension clause has been interpreted expansively, right? It means that the right of habeas corpus extends to non-citizens held outside the United States. That landmark decision was called Boumediene versus Bush. That said that it applied to non-citizens being detained at Guantanamo Bay. And the important thing there is that the Supreme Court's reasoning was that the United States had, this is the language from the opinion, complete and total control over the confinement of people who were being detained at Guantanamo Bay, which is one of the reasons why the administration keeps protesting that, no, we don't have any control over what happens to people who were sent to CICOT or to Ghana or to South Sudan, right? Like,
exactly.
It's all just up to them.
Yeah, I 100% agree that this is a bullshit thing and that they are trying it. Before we go, I want to talk about one of the other positive effects of the litigation, and that is publicity, right? Because the very fact that these cases are filed functions as a sort of a public media statement. It draws attention to the issues. And yes, I have made fun of people like Kash Patel for, filing garbage lawsuits to get attention. I do see the irony of my position. But the existence of this litigation does change facts on the ground. People don't like to be sued. People don't like to be shown to be doing bad things. And that extends beyond our borders. I think in the United States, we tend to think that the media ends here, or we only tend to think about the effect of what we do and how it's reported on the 330 million residents of this country. But it's a big world, and we've seen a couple of times that reporting and the litigation over these cases has embarrassed foreign governments and made them back away from these arrangements with the Trump administration. So we talked about in the DVD case, there were those men whom the government tried to rendition to South Sudan, and then they were stuck in Djibouti for a long time. And the South Sudanese government said, we're not taking these people. We're not taking them. We're not imprisoning them. We're just going to send them back to their countries of origin, which was a expression that they intended to illegally chain refool them. But it was also a kind of a freak out over the bad publicity from this litigation, right? When Abrego Garcia's wife sued, he was moved out of CICOT and moved to a less terrible and dangerous prison because the government understood that it had essentially screwed up and was facing a lot of blowback. And in fact, it's very funny. In the litigation over the DVD case, the petition to the Supreme Court said that publicizing this extra legal rendition to South Sudan had destabilized the nation of South Sudan.
Destabilized South Sudan. Yeah.
It destabilized South Sudan by embarrassing their government, by revealing that the government was going to do this kind of terrible deportation arrangement. And we've seen that here. Part of the reason that the plaintiffs in this case are able to point to all of these statements about the agreement, the memorandum of understanding between the U.S. and the Ghanaian governments, is because the publicity from this lawsuit and the reporting about it has embarrassed the Ghanaian government. And in fact, the legislature is saying, we're not doing this. What are you talking about? We're not doing this. If the government agreed to this and didn't bring it to the legislature to agree on, then it's illegal anyway. And so the fact that these lawsuits exist, sometimes they don't achieve in our court system the outcome that we would want. But they do put pressure on foreign governments because they shine a light on it. And it's embarrassing to be seen to be doing this categorically terrible thing, for foreign governments.
I want to seize on the last part of what you said because I agree with that 100%, right? I don't know that the Trump administration can be shamed. I don't know that our government can be pressured by adverse results. But what I hear you to be saying is regardless of that, we can make it more difficult on other countries that the Trump administration thinks it can just push around, right? And for which it obviously has open contempt. For example, I think the Trump administration thought that it was going to just bully Nigeria into accepting our deportees. And Nigeria said, no, we're not taking U.S. deportees. We're not going to serve as a third country parking spot and participate in the scheme. So I don't know that it's going to make it harder for the administration to operate domestically, but I think it is going to make it harder for the administration to find willing partners around the world, and that's a salutary result.
Yeah, and it might work in court, right? Sometimes it does work in U.S. court, right? We've talked a bunch about the Guatemalan children whom the administration tried to sneak out in the middle of the night, and they were stopped by the courts. So, okay, do not give up hope. We are still in this fight. That's going to do it for us today. And if you'd like to support us, lawandchaospod.com or patreon.com/lawandchaospod, or you can always leave us a 5-star review on your podcast platform of choice. A nice one. We would appreciate. All right. See you guys.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Up to Media, LLC, all rights reserved.